Next case that is set for argument is State of Ohio versus Christopher Baker. It is case number 29167. Both parties are represented by counsel for argument this morning, so each will have 15 minutes. The appellant may reserve up to 5 minutes for rebuttal. Just let me know and I'll keep you apprised of where you are at. We also have the time on the television there as well, so you can keep track of the time there. The court has read the briefs, and we are prepared to proceed if you are.
Thank you, Your Honor. May it please the court. My name is Ben Sorber. I represent the appellant Christopher Baker today. I'd ask that I be able to reserve up to 5 minutes of that time for rebuttal.
All right, very good. Thank you.
Today, we're asking is that the court vacate Mr. Baker's conviction for operating a vehicle while intoxicated and remand this matter back to the trial court. We've raised 3 assignments of error. I'm going to start with addressing the first 2 kind of in tandem because in this case, the sum and substance of the arguments for the first and second assignments of error are pretty similar. The first 2 arguments that we've raised in our brief is that the conviction itself was against the sufficiency of the evidence, and the second that the conviction is against the manifest weight of the evidence. Operating a vehicle while intoxicated, I think this presents a unique crime that we have in Ohio. A lot of the crimes that come before the court, there's specific elements, and it's kind of simple to check off whether the crime occurred by looking at those elements. So, for example, if we're looking at a carrying weapons while under disability, did the defendant have a weapon in his possession? If he did, was there a previous disability under Ohio or federal law that prevents him from carrying that weapon? If so, he's guilty. Operating a vehicle while impaired, we're left with this question of impairment. What constitutes that element? And there's no clear check like there is for weapons under disability or determining family or household member. It's kind of this hazy, are we over the line or are we not over the line? And that's kind of what this case is about. It's a very fact-specific question that the court has before it. Now, luckily in this case, we've got video of the traffic stop itself. And that video presents the best evidence of what happened that day, what condition, more importantly, that the defendant was in. In order for the jury to have found Mr. Baker of operating a vehicle while intoxicated or while impaired, they had to show that he was under the influence of alcohol. And not just that he had consumed alcohol that evening, but that the amount of alcohol he consumed was so much that his reasoning was impaired, his action time or his reaction time was impaired or diminished. Now, the Supreme Court of Ohio, in looking at the constitutionality of the accompanying per se charge of this crime in State versus Tanner, specifically went out of their way to say the law in Ohio doesn't prohibit drinking, it doesn't prohibit driving, it prohibits driving after excessive drinking. And that's really what we're looking at today, was Mr. Baker, had he had excessive drinking such that his condition was impaired? The jury lost their way when they determined that he was. Looking at the video, there just is not evidence from which they could have found that he was impaired that day. I'll concede that there was a traffic violation that led to the stop. I know that he was going well above the posted speed limit, but speeding alone is not sufficient indicia of impairment.
Are the field sobriety tests on the video?
The field sobriety tests are on the video.
And how did he do on the field sobriety test? What are we going to see when we watch the video as to the field sobriety test?
Right, so on the field sobriety test, the trooper testified that he found 6 out of 6 clues on the horizontal gait nystagmus test. You can't see the results of that test itself. That's the test where they're moving the pen about and looking to see if the eyes are bouncing.
Well, on that one, for instance, is the location of where he took the test. Is he looking into oncoming headlights? Are there police lights flashing in the area? Those sorts of things.
Right. It's hard to tell from the video if there were police lights flashing in his eyes when this happened, but there was more than one cruiser on the scene. This was a state highway patrol stop that happened in downtown Akron. And I would also note that it was about 3:30 in the morning, and it was snowing that day, so it was a cold winter morning. The officer testified that the defendant, Mr. Baker, had bloodshot eyes, but he's conceded that it was 3:30 in the morning. That could have been attributed to the time of day, and he also, Mr. Baker told the officer that he'd been up for about 17 hours. He'd worked a long shift and then had gone out with some friends afterwards.
Did he tell him he'd been drinking?
He did. He admitted to having 2 beers earlier in the evening at the bar and had driven his friends home, and he himself was alone in the car when he was stopped on the way back to his house. So it had been some time since his last drink. As to the other field sobriety tests, the trooper noticed clues on the walk and turn test. But there's some issues with how that particular test was done. On that test, one of the clues that he found was that the defendant took 9 steps and didn't turn and take the 9 steps back. Which generally that is a clue if the test is given with the instructions that you're supposed to give under the NHTSA manual, taking the 9 steps down and failing to turn around and take 9 steps back while counting those steps aloud, those would be clues on that field sobriety test. But in this particular case, before Mr. Baker started the test, he asked the trooper again, so he understood what the test was. And granted, this walk and turn, this is not something that people do every day. It's not something that you know how to do. So he asked the trooper, what am I supposed to do again? And the trooper said, take 9 steps down, count them aloud. The trooper doesn't say, turn around and walk back. So Mr. Baker takes his 9 steps down, touching heel to toe, counting each step aloud, and he gets to the end, and he turns around and looks at the trooper and says, what am I supposed to do now? And the trooper says, all right, are you done? I mean, he says that alone was indicia of impairment. But really, Mr. Baker performed the test well. He counted each step aloud. He took the 9 steps he was supposed to. He didn't step off the line. He wasn't stumbling, swaying, tripping, or anything like that. And he performed the test like the trooper told him to.
Counsel, the city is saying here that if we view the videotape, we're going to see that he was talking over the instructions and when the officer was trying to explain things to him. Is that what the video shows?
The video shows him having a dialogue with the trooper. The trooper is explaining the test to him, and he's asking for instructions. I think it's important.
While the trooper's talking, just like I talked over you.
Yes, Your Honor, and I know that neither of us are impaired right now. And I
It's
think
more
that's
difficult to understand questions and instructions you're talking over somebody about.
absolutely. But one thing I would note, though, is I think it's important to consider the time that this happened. I mean, this is 3:30 in the morning. Mr. Baker's worked a long shift. He just wants to get home. It's snowing out. He's trying to get through these tests, and every time he finishes a test, the trooper says, okay, we got this other thing to put you through, and we got this other thing to put you through. He just wants to go home and go to sleep.
Which is standard procedure, right? When you stop somebody for a DUI, to put them through different field sobriety tests.
Correct. And I'm not saying it was improper for the trooper to necessarily put him through those tests, but I think it's important to view Mr. Baker's frame of mind and the day that he had gone through and the fact that he wanted to get the test done and be on his way because he wasn't unimpaired. I mean, he was stopped for speeding and not using a turn signal. Granted, there's no other cars on the road except him and the trooper, and it's a 4-lane road. And now he's out in the cold and after a long day of work and trying to get home.
But he refused the portable breath test too.
He did, and he says, and you can see on the video, he tells the trooper, I'm done taking your tests, I just want to go home. I mean, by this point, he had already been out of the car for the HGN test, he'd already done the walk and turn, he'd already done the one-leg stand, it's cold, it's the middle of the night, and I think in his mind, the troopers aren't giving him any leeway. They're going to keep putting him through tests until they arrest him in his mind. I think he said, I'm done with your tests, I'm done with this, I just want to go home. So I don't think he wasn't saying, hey, I've been drinking, I'm not going to do that test. He says, no, I'm done with the tests, do what you're going to do, I'd like to go home. I'd also note on the one-leg stand, we don't see him swaying, stumbling, hopping about. When the trooper originally turns on his headlights, he pulls right over to the side of the road, although he was speeding, he wasn't swerving or weaving around. When he pulls over, he doesn't drive up on the curb. He produces his driver's license and his registration without any problems. I'm sure you've all heard, hundreds or thousands of these cases. That's always an indicator that troopers will testify to, is fumbling for your wallet, trying to produce those identification cards is a clue of impairment. We don't have that here because he produces that well. He's able to get out of his car and converse with the officers. And I think it's important to note his speech. He's not slurring his words. He's not, doesn't sound impaired. He's cognizant of where he is, what he's going to be doing. He's able to have thoughtful dialogue with the officers. And so based on the totality of everything, it does not rise to a level where the jury could have found that he was impaired. I think it's also important to note that the jury came back and told the judges they were deadlocked about 50-50, and after being read an Allen charge, they were able to then, at the end of the day, come back with a verdict of guilty. And somewhere along the course of their deliberations, after that Allen charge was read, they lost their way. Given the totality of what we see on the video, Mr. Baker's conviction is against the manifest weight of the evidence, and the evidence presented was not sufficient to find him guilty of that offense. And I'll reserve the balance of my time.
That'll be 4 minutes and 15 seconds for rebuttal.
Thank you.
Good morning, you've got 15 minutes.
Good morning, Your Honors. Brian Bremer on behalf of the state of Ohio. As Mr. Baker laid out, there are 3 assignments of error in this case. Mr. Baker was convicted for operating his vehicle while intoxicated, and he has challenged the sufficiency of the evidence presented at trial, the manifest way of the evidence, and also he has raised an issue regarding a statement that was struck by the court during the testimony at trial. And like Mr. Baker said, I think that the overview of the first 2 assignments of error helps inform the discussion about the third one. So I was beginning by talking about the evidence presented at the trial. In this case, Mr. Baker, as an initial matter, there's some discussion about the field sobriety tests and how they were conducted. And the one thing I would say is that when you review Mr. Baker's brief, he never actually argues about the field sobriety tests in either his first assignment of error or his second assignment of error. He never mentions them. And therefore, he's not actually developed arguments about what weight you should give those tests. And for that reason, he's basically forfeited that argument for the purposes of this appeal. Furthermore, when you review the arguments that he actually raises, he basically says that the only indicia of intoxication in this case was that Mr. Baker had bloodshot glassy eyes, that he admitted to drinking, and that the officer stated on the video that he smelled a slight odor of alcohol. However, that disregards significant portions of the testimony in this case. In this case, the trooper stated that he observed him driving at 64 miles an hour in a 35-mile-an-hour zone at 3:30 in the morning. He saw him fail to use a turn signal. When he walked up to the car, he said, "I smelled a strong odor of alcohol." I said slight as a conversation, basically as a conversation starter. It was clear from the trooper's testimony that he said his position was, I smelled a strong odor of alcohol, but I did not say that to him because I was concerned that it was basically going to cause him to stop talking to me. Mr. Baker admitted to drinking. He said he was coming from a bar. And when the officer had him perform the field sobriety test, the officer observed 6 out of 6 clues for the horizontal gaze and nystagmus, and he observed 6 out of 8 clues in the walk and turn test. And Mr. Baker brings up the fact that he was only told to do 9 steps, and that typically, in failure to do a 10th step, would be a basis for finding intoxication. However, Mr. Baker was instructed to take 9 steps, and then he took 10. So basically, the issue was he still disregarded the instruction that was given to him by the officer. And further, then when he did the one-leg stand, he only showed 1 out of 4 signs in that test. He refused to take a portable breathalyzer test, and then he was arrested, and he refused to take the breathalyzer test at the station. And when you view all that evidence in light most favorable to the state for purposes of sufficiency, that is ample evidence to show that he was intoxicated and he had been operating his vehicle while he was intoxicated. The jury was told that those field sobriety tests are used to show signs of intoxication, that they've been shown scientifically to demonstrate intoxication. So they were aware of the fact that the purpose of the field sobriety test and what the indicia was the purpose of noting the indicia of intoxication. So for that reason alone, the first assignment of error should be overruled. With regard to the manifest weight assignment of error, as we noted in our brief, Mr. Baker does not actually separately argue manifest weight. Sufficiency and manifest weight are inherently different analysis, and they require different arguments. Mr. Baker has not only incorporated his argument from his sufficiency of the evidence. This court has held that is not good enough for purpose of preserving the argument for an appeal. You've held that before the briefing, which I cited in my brief, and you've held that subsequent to this our brief being filed in this case. Furthermore, Mr. Baker even articulates his second assignment of error by saying there was not sufficient, his conviction was against the manifest weight because it wasn't supported by sufficient evidence. Again, there was sufficient evidence, and furthermore, the issues that Mr. Baker raises, like he could have been tired, he said he only had 2 drinks. The officer said at the scene that it was slight odor, then he said it was strong at the trial. These are all issues that the jury was aware of. They were brought out to the jury was free to weigh that evidence, and they're free to believe any or all of the testimony of the people that was presented to them. In this case, they believed the state's witness, they believed the evidence, and they found that Mr. Baker had operated his vehicle intoxicated. This is not the outlier case that the jury so clearly lost its way that it created a manifest miscarriage of justice requiring reversal. His conviction is not against the manifest weight of the evidence, and therefore his second assignment of error should also be overruled. Addressing his third assignment of error, which is that Mr. Baker argues that there should have been a mistrial in this case. And his basis for that is that during the trial, they were observing the video was being played to the jury showing Mr. Baker's arrest. And in that video, Mr. Baker says something to the effect that, "I never mentioned Bud Light." And the prosecution said, "What is he talking about?" And the prosecutor asked the witness that, and the witness said, "My partner found a Bud Light can in his car. That's what he's talking about." And immediate objection. The objection was that it was hearsay. The court agreed, immediately struck the testimony, and ordered the jury to disregard it. Juries are presumed to follow the court's instructions, and there's no evidence in this case that the jury failed to do so. It's also important to note that in this case, the hearsay statement that he's objecting to wouldn't rise to the level of mistrial. Mistrials are a very harsh sanction. They should only be granted to really prevent a miscarriage of justice. And in this case, the statement was there was a Bud Light can in the car. As Mr. Baker points out, there's no testimony that it opened. There's no testimony that implied that Mr. Baker had been drinking it. They just said he found a can, and it was explaining something Mr. Baker said himself in the video that had been played for the jury. Mr. Baker's statement about the Bud Light can, about Bud Light, was not struck. And so it's already in there that there's some idea about Bud Light, but what the trooper said was not prejudicial, and it was also immediately struck, and the jury followed the court's instructions. And if you also review all the evidence in this case, there's bordering on overwhelming evidence of intoxication. Again, he'd been driving, he was speeding late at night, coming from a bar. He admitted to drinking. He showed 6 out of 6 signs on the HGM test, 6 out of 8 signs on the walk and turn test, and then he refused to take the breathalyzer test both at the scene and at the station. That's all evidence the jury had before it, and the jury, and we believe that evidence. It's more than enough to convict Mr. Baker of driving while intoxicated, and there's no reason to believe that the stray mention of a Bud Light can was what affected the outcome of the case, especially since it was immediately struck and the curative instruction was given.
What's your position about why the jury was struggling and giving an Allen charge?
I can only speculate about that. There's any number of reasons, and there's no reason to believe it had anything to do with the Bud Light can, which again,
That's what I'm saying, if the evidence was like borderline overwhelming, I don't understand why we would need an Allen charge.
some people, well, again, I would be pure speculation, Your Honor, I don't know, I don't even know if the jury was subsequently polled, not that that could be, used to really evaluate the situation. But I would also note that I think there are people, you could be weighing whether you want to believe the officer about the slight odor of alcohol or the strong odor of alcohol. Maybe people just don't believe in, that there might have been jury nullification happening in the back room. Who knows? Like, it's pure speculation. And there's no reason, there's no question asked about, like, there's no question the jury, like, asked the court, like, oh, can we consider the Bud Light can? Or, like, there's nothing coming from the jury indicating that they're talking about the Bud Light can back there during the course of this deliberation. So it's pure speculation, and there's no reason to really believe that was happening. And for that reason, Mr. Baker can't demonstrate that he's entitled to a mistrial in this case, and therefore his third assignment of error should also be overruled. And if there's no further questions, I will rest by stating that we respectfully request that all 3 assignments of error be overruled and that Mr. Baker's conviction be affirmed. Thank you.
All right, thank you. Counsel, you'll have 4 minutes and 15 seconds then for.
Thank you, Your Honor. So, to start briefly with the issue of the mistrial, I agree with Mr. Bremer that typically this is a harsh sanction, but it is a sanction that exists in our system to ensure justice. I understand that this is a small statement that was made at trial, that was stricken, and that the jury was instructed to disregard it. But I think that's downplaying the bigger picture of this trial, and it's important to look at the context of this trial. This was a very short trial. The jury only heard from one witness, and that was the trooper. The whole trial, jury selection and verdict only took 1 day. So this was not one comment that was made over the course of a 2-week trial, and we can assume the jury just properly disregarded it. I think given what the information that they had before them, this rises to a much larger issue, and that's why we raised the assignment of error, and it's one of the assignments of error we asked the court to sustain. I know that Mr. Bremer has made the point that under Appellate Rule 7, the manifest weight argument can't be considered. I would just point this court's attention to State v. Rafferty and State v. Feliciano. They were both 9th District cases where a separate argument was not set forth in a manifest weight argument, but this court nonetheless went on to consider the merits of that argument. And given the issues in this case and the way that the brief is set out, I believe that the court can and should do that here. And finally, I note that courts have stated in Ohio that it is perfectly legal to be at bars in the early mornings. It's perfectly legal to have a drink at the bars. It's even perfectly legal to drive home. What the law prohibits is driving while impaired. And the state's burden at trial was to prove beyond a reasonable doubt that Mr. Baker was impaired, that his functions, that his action time, that his reaction time, that his cognitive abilities were impaired. Viewing the totality of the evidence before it, the state did not meet that burden at trial. The jury's verdict was not sufficient given the evidence, and the jury's verdict was against the manifest weight of the evidence. And for those reasons, we're asking that this court vacate Mr. Baker's conviction and remand this back to the trial court. Thank you.
All right, thank you both for your arguments this morning. The court will take the matter under advisement, issue a decision in due course. The clerk of courts will mail each of you a copy of the court's decision on the day of release, and you can also find the court's opinions on the Supreme Court of Ohio's website. We're going to take a short recess.